Previously, we have learned the register office of a company under Section 10. Now we are going to learn the Section 10A about commencement of a business. There are conditions for the commencement of a business in Companies Act 2013. That is, a company incorporated after the commencement of the Companies Amendment Ordinance 2019 and having the share capital shall commence any business or exercise any borrowings power only if the company has filed with the registered verification of its registered office as provided in subsection 2 of section 12, and a declaration is filed with the registered by a director within a period of 180 days of the date of incorporation of the company in form number INC 28 duly verified by a company secretary or a chartered accountant or a cost accountant in practice, along with the prescribed fee, that every subscriber to the memorandum has paid the value of the share. So he has to give the declaration in which he has to mention it should be in the form number INC 12, and it should be filed within a period of 180 days of the date of incorporation of the company. And in that declaration, he has to mention that every subscriber to the memorandum has paid the value of shares agreed to be taken by him on the date of making of such declaration. Then notes section 12, subsection 2, verification of register office with registrar discussed earlier hearing. So that's 15 in this chapter. In the case of a company pursuing objects requiring the registration or approval from the sectoral regulators such as the Reserve Bank of India, SEBI, etc., the registration or approval, as the case may be, from such regulators shall also obtain and attach with such declaration. So, with that declaration, we have to give verification of register office of registrar. That a verification also we need to provide to the registrar, and the regulator approval should be attached with the should be attached filed with the registrar before commencement of the business. Now, outcome where conditions are not satisfied. There should be penalty if the conditions have not been satisfied. If any default is made in compliance with the requirements of this section, the penalty shall be for company it is 50,000 rupees. Every officer with default has to pay 1,000 rupees per each day during which such default continues, but not exceeding 1 lakh rupees. For 1,000 rupees for every day, but should not be greater than 1 lakh rupees. So 1,000 per day up to rupees 1 lakh for every officer with default, and for company it is 50,000 rupees. Declaration not filed by a director within 180 days, where no declaration has been filed by directors within a period of 180 days of the date of incorporation with registrar, and the registrar has a reasonable cause to believe that the company is not carrying on any business or operation. He may initiate action for removal of the name of the company from the register of the companies under Chapter 18. Action by registrar for removal of name can be take place simultaneously with levy of penalty. Then we will see the conversion of a company in section 18. Section 18 of the Act empower a company to convert itself into some other class of company by altering its memorandum and articles of association, following the law with respect of the conversion of the companies already registered by alteration of memorandum and articles by a company of any class registered under this Act may convert itself as a company of other class under this Act by alteration of memorandum and articles of the company in accordance with the provisions of this chapter. File an application to the registrar. Wherever conversion to be done under Section 18, registrar on the basis of an application filed filed by the company shall, after satisfying himself that the provisions applicable for the registration of the companies have been complied with, close the formal registration of the company, and after registering the required documents, issue a certificate of incorporation in the same manner as dispersed registration. Student may also refer section Rule 677A and 20 to 22 of the Companies Incorporation Rules 2014 and 37 and 38 of the Companies Incorporation Rules 2016 and form number INC 5 and INC 6 under the Companies Incorporation Rules 2014 and INC 27 under Companies Incorporation Rule 2016. No effects on the dates, liability, etc. incurred before conversion. The registration of a company under this section shall not affect any dates, liabilities, obligation, or contracts incurred or entered into by or on behalf of the company before the conversion of such dates, liability, obligation, and contracts may be imposed in the manner as if such registration had not been done. To put in more simple way, the company remains the same entity as it was before in respect of its rights, liability, obligation, or contracts. So we have seen two important sections, Section 12 about registered office and Section 10A about commencement of business. And next, and Section 18 regarding conversion of a company from one class of company to another class of company, just by altering its memorandum and articles of association and filing with registrar of such conversion, and registrar will provide a new place certificate of incorporation in that case. But in such case, no, there will be no effect on the debts, liabilities, and obligations and contract. It will remain the same entity as it as before with respect to its debt, liability, obligation, and contract. Now we will see the subsidiary section 19 of the Companies Act 2013, which deals with the that it is that subsidiary company not to hold shares in its holding company. It says as per section 19 of the Act, a subsidiary company is not allowed to hold shares of its holding company. The prohibition also extends up to the nominees of the subsidiary company. The subsidiary company cannot hold the shares in the holding company, as well as the nominees of the subsidiary company also cannot hold the shares in the holding company of the subsidiary company. Consequently, any allotment or transfer of shares in a holding company to its subsidiary company, any allotment or transfer of the shares in a holding company to its subsidiary company shall be void. If the holding company is a guarantee or unlimited company not having share capital, the above restriction will apply on holding the interest, whatever is the form of interest. And prohibition does not apply to the following cases. There are three exceptions where the subsidiary is concerned as a legal representative of a deceased person of the holding company. If it is a legal representative of a deceased person, this is a member of the holding company, and where the subsidiary holds the shares as a trustee, or where the subsidiary company is a shareholder even before it becomes a subsidiary company of the holding company. Tried to vote at a meeting of the holding company only in respect of the shares held by it as a legal representative or as a trustee. Prohibition does not apply to the case of a subsidiary company which already had shares in its holding company at the commencement of the Act, and a subsidiary can buy shares in its holding company where it is a part of the scheme of amalgamation sanctioned by the court or tribunal. Okay. Now, RPP Limited has invested 51% of the shares of SSP Limited Private Limited on 31st March 2023. SSP Private Limited have holding 2% equity of RPP Limited since 2013. SSP Private Limited cannot increase its equity beyond that 2% on after 31st March 2023. However, it will continue to hold or reduce its initial 2% stake. Okay. Now we will see the third category of this chapter based on the documents, in which we will see section 20, 21, and 22. Those are the service, authentication, and execution of the documents. Here we will see the service of documents, section 20 of the Companies Act 2013, really the rule 35, service of documents of companies reincorporation rules 2014. Provides the mode in which the documents may be served on the company, on the members, or also on the registrar. Law with respect to the service of documents is as follows. Serving of documents to the company or an officer there, a document may be served on the company on an officer thereof by sending it to the company or the officer at the registrar office of the company by registered post, speed post, or courier service, or leaving it at its registered office and means of electronic form, or other modes as may be prescribed. However, where the securities are held with the depository, the records of the beneficial ownership may be served by such depository on the company by means of electronic or other mode. Serving out documents to registrar or members, save as provided in this Act or rules made thereunder for filing of documents with the registrar in electronic mode. A document may be served on a registrar or delivered by sending it to him by post, register office, speed post, courier by delivering at his office or address, or by such electronic or other mode as may be prescribed. Courier also is option there. Courier service, speed post and registers post. Registers members, couriers are living at register office, living at as register office and by any such an electronic or other mode as may be prescribed. However, a member may request for a delivery of any document through a particular mode for which he shall pay such fee as may be determined by the company in its annual general meeting. Now, for the purpose of this section, the term courier means a person or agency which delivers the document or provides proof of its delivery. The term electronic transmission means a communication that creates a record that is capable of retention, retrieval, recovery, or review, and which may thereafter be rendered into a clearly legible, tangible form. It may be made by telecommunication, that is fax and electronic email, which the company or the officer has provided from time to time for sending communication, posting of an electronic message board or a network that the registrar or the member has designated for those communications and which transmission shall be validly delivered upon the posting or the other means of electronic communication in respect of which the company and the officer has put in place reasonable system to verify that the sender is the person purporting to the send of the transmission. Further subsection 2 provides in case of delivery by post, such service shall be deemed to have been effected in case of the notice of the meeting and in case of notice of meeting at the expiration of 48 hours after the letter containing the same is posted, and in other case, at the time at which the letter would be delivered in the ordinary course of post. So, in case of a notice of a meeting, it should be considered as and be delivered. It should be considered as have been delivered with the expiration of period of 48 hours after the letter containing the same has is posted, and in other case, at the time at which the letter would have been delivered in the ordinary course of post. Now, Section 2020, subsection 2 shall apply to a needy company, subject to the modification that the document may be served only on members who hold the shares of more than 1,000 in face value or more than 1% of the total paid up share capital, whichever is less. The document may be served only on members who hold the shares of more than 1,000 rupees in face value or more than 1% of total paid up share capital. And for other shareholder, document may be served by public notice in newspapers circulated in the district where the register office of the Navy is situated, and the publication on the same on the notice board of the Navy. Then example, Model Furniture Center notice of a general meeting through postal mail 48 hours after the post of the later containing such notice shall be deemed to be served. Hence, the requirement of a 21 clear days notice under Section 101 of the Act, if seen in this context, Modern Furniture Limited should have posted the later containing notice 23 days prior to the meeting day, 48 hours of the post delivery plus 21 clear days. Okay, now authentication of documents, proceedings, and contracts. Now using the Section 21 regarding authentication of documents. As per Section 21 of the Act, a document or proceeding requiring authentication by a company or contracts made on behalf of the company may be signed by a key managerial person or an officer or employee of the company duly authorized by its board in this behalf. In the case of a specified IFC company or a private company, would an officer read as an officer or any other person? An officer or any other person. Now, execution of bills and bill of exchange and other documents in your hundi promissory note shall be deemed to have been made or accepted, drawn, and endorsed on behalf of a company, made or accepted, drawn, or endorsed in the name of or on behalf of or on account of the company by any person acting under its authority. Authority can be either expressed or implied. Formal deeds can be executed only through a power of attorney. Therefore, subsection 2 and 3 may together provides a company may by writing underneath its common seal any wherein case of a company does not have a common seal, they are authorized by two directors and by or by a director and a company secretary, wherever the company has appointed a company secretary, authorizing the person or either generally or in respect of specified matters as its attorney to execute other deeds on its behalf or in any place, either in or outside India, deed signed by such an attorney on behalf of the company and under his seal shall bind the company. Summary of subsection 2 company having seal. If no, then authorization shall be made by two directors or where the company has a company secretary, but then by a director along with company secretary. And if it has the common seal in writing authorized by any person generally or in respect of any specified matters as attorney in India or outside India. A note, it can be observed from above that a company may or may not have a common seal. If the company decides to have common seal, then it has to affix the same for the specified matters execution of deeds on behalf of the company. The seal is a method of making a physical impression upon the documents of the company of its name, etc. Section 22 comes into play when a person wants to impose obligation against a complying arising out of the contract and the company denies the contract or disputes its liability. The section cannot be used where the proceedings is by the company. Summary: once an association become incorporated, it acquires a legal status. It becomes a separate legal entity in its own right and separate from the individual members. It will have a perpetual succession, so that not affected by the death, insanity, or insolvency of an individual member. Earlier, the certificate of incorporation considered as a conclusive proof, but as per the Companies Act 2013, certificate of incorporation is not a conclusive proof of everything prior to incorporation. Remember, CIN is a 21 alphanumeric digit-based unique identification number comprising of data sections or elements that